we ready for appearances?
The plaintiff is ready, Your Honor.
Defense is ready as well, Your Honor.
Okay, well, good morning, good afternoon, depending where you are. Let's hear from the plaintiff.
Yes, Your Honor, good morning or afternoon. My name is Seva Castleberry, and today I'm joined by Mr. Jacob Hervey.
Good afternoon, Your Honor.
Good afternoon.
Mr. Hervey will be dealing with our technology and our exhibits today.
Sounds
Together,
good.
we represent the estate of Jessica Marks.
And defense?
Good morning or afternoon, Your Honor, depending on your time zone. My name is Caitlin Hunt. Today I'll be joined by an off-screen co-counsel who will be assisting with the technological portions of today's proceedings. And together, we represent the defendant in today's case, Sonny's Rooftop Bar.
Good morning or afternoon. Do we have any pretrial matters before we begin?
Yes, Your Honor, just a few. First of
Let's
all,
hear
we'd
them.
like to invoke, thank you, Your Honor. First of all, we'd like to invoke Rule 603 and 615. That's the constructive swearing in of all witnesses and the constructive sequestration of all witnesses. Now, per Rule 615, our witness, Mr. Morgan Levin, will be sequestered.
Any objection?
No objection, Your Honor. We'd just like to note that Sonny Mehta, the owner of Sonny's Rooftop Bar, will be present throughout today's proceedings.
Sounds good.
Now, next, Your Honor, since this is a wrongful death suit based on a unique California statute that punishes selling alcohol to minors, I'd like to draw your attention to the jury instructions made by the pretrial judge so that we can lay out the issue in today's case. Your Honor, here it says that under California law, a bar is liable for any injury or death caused by the selling, furnishing, or giving of alcohol to any obviously intoxicated minor.
Okay.
Now, Your Honor, on that obviously intoxicated point, the pretrial judge also explained that obviously intoxicated is an objective, reasonable person standard. So that means that when the defendant served Jessica Marks alcohol, she displayed symptoms that would lead a reasonable person to conclude that she was obviously intoxicated.
Okay, understood.
Okay, and finally, Your Honor, we'd like to direct your attention to one stipulation. Stipulation 14 says that Jessica Marks was born on January 20th, 2000, meaning on the day of the incident, March 24th, 2019, she was 19 years old.
Got it. Thank you.
With that, Your Honor, the plaintiff's
Anything
ready to
else?
proceed.
Anything from defense before we move to openings?
Yes, Your Honor. We'd like to direct your attention to the pretrial order. We'll be displaying that for your reference.
Thank you.
Of course. Specifically to paragraph 7, once exhibits are admitted, counsel performing an opening, examination, or closing may display such exhibits on the screen at any time without specifically requesting permission.
Sounds good. Feel free to put them up once they're in evidence.
With that, Your Honor, defense is ready to proceed as well.
Okay, let's hear from the plaintiff. Opening statements.
Yes, Your Honor. Before I begin, can you see and hear me okay?
Yes, I can. Thank you.
Your Honor, opposing counsel, members of the jury, may it please the court. They served, they saw, and they still didn't care. On March 24th, 2 years ago, a 19-year-old girl named Jessica Marks was driving on the highway. She was drunk, losing consciousness, slurring her words, she couldn't see straight. Suddenly, Jessica lost control of the wheel. The car went off a bridge and landed upside down at the bottom of a cliff. Jessica was dead. But members of the jury, today you're going to learn that Jessica's death could have been prevented. See, just hours before she died, Jessica walked into the defendant's bar. She was underage, but they didn't care. Instead, they gave her drink after drink for hours. She started slurring her words, but the defendant gave her another glass of wine. She couldn't walk straight, but the defendant gave her more pints of beer. She told the defendant that she was going to drive home, but the defendant poured her another shot. And when the defendant let that 19-year-old girl stumble into her car, well, Jessica never had a chance. And that's why Jessica's family is suing the defendant for what's called wrongful death. See, members of the jury, the law says that when a bar knowingly sells alcohol to a drunk minor, and then that minor dies because she was drunk, the bar is liable for her death. Now, that means we have to prove to you that it's more likely than not three things: that Jessica was obviously intoxicated, that the bar served her drinks anyway, and that the bar's actions helped cause her death. And members of the jury, we'll meet that burden. We'll meet that burden by showing you that they served, they saw, and they still didn't care. So I want to walk you through each part of our case. First, we'll show you how much alcohol the defendant served Jessica Marks. Today, you're going to hear from Jessica's best friend, Morgan Levin. Mr. Levin was with Jessica at the bar the whole night. He'll tell you that the defendant served Jessica an entire bottle of wine, multiple pints of beer, and shots. He'll tell you that Jessica was visibly drunk, but the bar kept serving her. Second, we'll show you that the defendant saw just how drunk Jessica got. You'll learn that the owner of the defendant bar, Sonny Mehta, saw Jessica lose her balance, heard Jessica slurring her words, and smelled the alcohol on Jessica's breath. In fact, the defendant saw Jessica fall down the stairs because of how much alcohol she had been drinking. But the defendant kept giving her more. Finally, we'll show you that the defendant just didn't care about the danger they were putting Jessica in. You'll learn that late in the night, Jessica told the owner of the defendant bar that she was going to drive home. When he heard that, he didn't call Jessica a taxi or tell her to take an Uber or even take her keys. No, instead, he poured Jessica another shot and then let her stumble out the door to her car. They just didn't care. Members of the jury, I want you to remember that we're here today because of Jessica Marks. As you sit through this trial, it might become easy to forget that Jessica was anything other than a college student who got too drunk one night. You'll see that Jessica Marks was more than that. She was the daughter of a loving mother, a brilliant student with a bright future, and a good friend. When Jessica Marks died, she didn't get to graduate college. She didn't get to grow up, start a family of her own, or live a life. We can't bring Jessica Marks back. And in a court of law, there's one thing we can do. We can give her family justice. We can do that by holding the people who caused her death accountable. That's why at the end of this trial, I'm going to come back up here and ask you to find Sonny's bar liable. Thank you.
Thank you. Can we now get the opening from defense?
Yes, Your Honor. May I proceed?
You may.
Counsel, members of the jury, may it please the court. It's about what we knew and when we knew it. We as the defense agree that today's case is a tragedy. A young woman lost her life behind the wheel of a car after making the decision to drink and drive. It is undeniably tragic. When tragedies like these occur, it's human nature to want to find someone or something to blame, to search for the easiest target. That's what the plaintiff has done. Their target? Sonny's rooftop bar, the bar that Jessica Marks was at on March 24th of 2019. But the law tells us we can't stop with the easiest target. We have to look at everyone's actions, and no matter how uncomfortable it might be, that includes looking at Jessica Marks' actions the night of March 24th, 2019. You see, I anticipate that throughout today's trial, the plaintiff is going to be playing a lot of Monday morning quarterback. He's going to tell us a lot of things we know now. We know now Jessica was too intoxicated to drive. But the law tells us it's about what we knew then. What we knew the night of March 24th, 2019. And you're going to hear that what we knew then is that Jessica Marks seemed sober. What you're going to hear today is that nobody, not the bar owner, Sonny Meta, not the bartender, not Jessica's best friend, and maybe not even Jessica herself, knew that Jessica was too drunk to drive. And that's important, because even though this doesn't look like a typical courtroom, we are still here today for a trial. And that means the plaintiff, well, they have a burden. They have to prove their case to you today by a preponderance of the evidence. And they have to prove two elements. And first, that the bar served Jessica while she was obviously intoxicated. And second, that played a substantial role in her death. They're not going to be able to meet that burden for you today because the evidence will show that Jessica was not obviously intoxicated. You're going to learn that the plaintiff's case that she was obviously intoxicated, it rests on the word of one man who was himself intoxicated that night. Morgan Levin, Jessica's best friend, will take the stand today, and he'll tell you how much he had to drink that night. It'll become clear that there are entire portions of that night, significant events that Morgan Levin doesn't remember. But even Morgan Levin knew in that moment that Jessica appeared sober enough to drive. But that's why we're going to call our own witness to the stand. Someone who was not drinking the night of March 24th. Sonny Meta, the owner of Sonny's Rooftop Bar, will take the stand. He's going to tell you that he's trained to look for signs of intoxication. He knows when someone is obviously intoxicated, and he knows when to cut someone off. But that Jessica Marks did not appear obviously intoxicated. She seemed sober enough to drive. Members of the jury, we know now that she wasn't. We know now that Jessica Marks got behind the wheel of that car and that she tried to drive home. That's why we'll be taking on a burden today as well. We intend to prove what's called an affirmative defense. We intend to prove by a preponderance of the evidence that Jessica Marks's decision to drive that night played a role in her death. Now, we'll talk more about that later, but for now, I want you to keep in mind three questions throughout today's trial. First, when, if at all, did Jessica Marks appear obviously intoxicated? Second, most importantly, was any employee at Sonny's bar there to see it? And third, did Jessica Marks's decision to drive play a role in her death? This does not mean her death was not a tragedy. But the law requires us to look at the facts, even the ones that are uncomfortable. The law requires us to look at what we knew and when we knew it. And that's why at the end of today's trial, I'll come before you again, and I'll ask that you find Sonny's Rooftop Bar not liable. Thank you.
Thank you, Ms. Hunt. Are we ready to proceed? Plaintiff, call your first witness.
We are, Your Honor. Thank you. At this time, the plaintiff calls Morgan Levin to the stand.
Mr. Levin, you've been constructively sworn in.
Mr. Levin, just for some clarity, if you could rename yourself.
Sorry.
Sorry about the delay, Your Honor.
No problem at all.
May we proceed?
You may.
Mr. Levin, can you introduce yourself to the jury?
Hi, my name's Morgan Levin.
Can you tell us how you know Jessica Marks?
Jess was my best friend. We grew up together. We'd known each other since we were basically toddlers.
Were you with Jessica on the night of March 24th, 2019?
Yeah, I was. That was the night that Jessica, she died.
If it's all right, I need to ask you a few questions about that.
Sure.
Where were you and Jessica on that night?
We were in LA. She came to visit me for spring break because she went to school in Philly. We went to this place called Sunny's Rooftop Bar.
I want to try to keep track of the things that happened that night. Mr. Hervey, can we get a timeline on the screen? Sir, about what time did you and Jessica get to Sunny's bar?
Around 9 p.m.
When did you leave?
Around 11:45.
Sir, between 9 and 11:45, did you see the defendant serve Jessica alcohol?
Yeah. This guy, Sonny, I think he was the owner of the bar. He kept coming up to our table and ordering, serving us drinks basically the entire night.
I want to take a closer look at how much alcohol the defendant served Jessica. Mr. Hervey, can we get Exhibit 14 on the screen? Sir, what is this?
It's a picture that I took that night on my phone. It's some of the drinks that Sonny gave us.
Plaintiff moves 14 into evidence, Your Honor.
Any objection?
Without objection, Your Honor.
It's in.
Sir, when was this picture taken?
I can't tell you the exact time, but it had to be between 9 and 11:45. It was while we were at the bar.
Well, can you tell us which of these drinks the defendant served to Jessica?
Yeah, almost all of them were for her. The glass of beer on the left, the wine, those 2 White Claws, they were all for Jess.
Mr. Hervey, can we get those drinks on the timeline? Sir, did that photo show every drink the bar served Jessica that night?
No, she drank another White Claw. It was 3 in total. And she drank more from that bottle of wine. I mean, it had to be at least 2 glasses.
Mr. Hervey, can we get that on the timeline as well? All right, sir, so I'm seeing 1 pint of beer, at least 2 wine glasses, and 3 White Claws. Sir, how was Jessica acting around the time she was drinking?
Well, she was stumbling all over the place, slurring her words, her eyes were bloodshot.
I want to talk about whether the defendant saw how the alcohol affected Jessica. Sir, when Jessica was slurring her words, like you said before, was she around any employees?
Yeah, of course. The owner, Sonny, he kept coming up to our table, talking to us, taking our drink orders.
How many times did Sonny come to your table when Jessica was acting like that?
A lot. I mean, it had to be at 8, 9, maybe even 10 times.
You also said earlier that Jessica was stumbling. Do you know if the employees ever saw that?
Yeah. Around 10, Jess and I were walking down the stairs. She had to go to the bathroom. And she was super off balance and she tripped. And she basically fell down the entire flight of stairs. And Sonny had to catch her at the bottom.
Did you hear Sonny say anything?
Yeah. He just looked at the bartender and said, "We might need to cut this one off."
So after the bar's owner told the bartender to cut Jessica off, did they stop serving Jessica drinks?
No. They kept serving her drinks after that.
Okay, well, once the defendant served her more alcohol after she fell down the stairs, how was Jessica acting?
She got worse. She couldn't stand up straight. Could barely string 2 sentences together. She was yelling and screaming, but nothing really made sense.
Mr. Levin, do you have any videos of Jessica from that time?
Yeah, I took a video. I was going to put it on my story.
Mr. Hervey, can we get that video on screen? And Mr. Levin, before we play this video, can you tell us what's in it?
Sure, it's just a video of Jess that night.
Plaintiff moves exhibit 10 into evidence.
Any objection?
Without objection, Your Honor.
Mr.
Play the
Hurley, can you
video.
play that video?
We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
About what time did you record that video?
11.
Can we get that on the timeline, Mr. Hurley? So after you took that video, did Sonny say anything else to you about Jessica's drink?
Yeah. Jess was trying to order another drink, and Sonny came up to us. He pointed at Jess and looked at me and said, "I hope this one's not driving."
Sir, I have to ask. After the defendant said, "I hope this one's not driving," did he serve you all any more drinks?
Yes. He ordered us a whole round of shots.
What happened at the end of the night when Jessica stopped drinking?
I paid for our tab. We went outside. I ordered an Uber. I didn't feel safe driving with Jess, but she got in her car and she drove away. My Uber was right behind her.
What happened when Jessica drove away from the defendant's bar?
She made it a couple hundred feet to the bridge. Then her car swerved out of nowhere and she fell.
Can we get exhibit 18 up for the jury? Mr. Levin, I'm sorry, but can you tell us what this is?
It's a picture of Jess's car. It's what it looked like when it landed. It's the picture that was all over the news.
Plaintiff moves 18 into evidence.
Any objection?
Without objection, Your Honor.
It's in.
Do you remember what time that crash happened?
About 11:45.
All right, sir. Now, before I let you go, I need to ask you a few questions about whether the defendant cared about Jessica's safety. You said before that Jessica was slurring her words and stumbling that night. At any point, did you see anyone working at the defendant's bar refuse to serve Jessica drinks?
No.
At any point, did you see anyone working at the bar call Jessica a cab?
No, I didn't.
To your knowledge, what did the employees at the bar do as you were leaving that night?
Nothing. They just gave us those shots. And they let Jessica walk out the door.
Thank you, sir. Nothing further.
Cross?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Mr. Levin.
Good afternoon.
I want to break down the timeline of March 24th, 2019, okay?
Sure.
The first time you saw Jessica that day, it was 6 p.m., right?
That's true.
She picked you up from your dorm,
Yeah, she was staying in an Airbnb.
and the two of you went back to her Airbnb, like you said.
Yes.
Now, while you were at that Airbnb, you saw Jessica drink 1 or 2 glasses of wine, true?
Yeah, we were finishing a bottle that she had in her Airbnb.
You yourself had 1 glass of that wine, didn't you?
Yeah, just a glass.
The two of you got in the car.
Yes.
And Jessica drove you to Sunny's rooftop bar.
Yeah.
That was from 8:30 to 9 o'clock, wasn't it?
Yeah. It takes about 25, 30 minutes to get there. It was in Malibu, so it wasn't near my campus.
Now, during that 30 minutes, Jessica wasn't drinking, was she? Not while she was driving.
No, she wasn't.
And during that 30 minutes, while she was driving, she appeared to you to be sober.
At first, yeah.
Even though you knew she had had a drink or two, she appeared sober.
Yeah. I mean, at first she did, but then when we got to the bar, she started kind of slurring her words a little bit. She seemed maybe a bit buzzed, but in the car, yeah, she seemed sober.
Well, let's break that down. You got to the parking lot of Sunny's rooftop bar, and then Jessica showed some signs of intoxication. True?
Yeah, just a little.
This was in the parking lot where no employees were present.
Yes.
And then you walked in the bar.
Yeah, we walked in the bar.
You both drank alcohol.
Yes, we did.
You know, sir, that alcohol, it can impair memory, don't you?
Sure. Yeah, if you drink too much.
So I'd like to talk about your memory of that night. You know that you and Jessica ordered a bottle of wine as your first drink, right?
Yeah.
You know that you ordered this bottle of wine up on the roof.
Yes.
It's your testimony you had one glass of that wine.
Yes. Jess had a few more though.
Isn't it true, sir, that after that one glass of wine, you don't remember a lot about that night?
That's not true.
Sir, you don't remember after that glass of wine where you ordered any of the other drinks?
I said I wasn't sure who ordered what, but
You don't know, sir, where you ordered those other drinks?
Objection, Your Honor. I ask that opposing counsel let my witness finish his answers.
Yes, just let him finish speaking and then feel free to ask your next question. No
Yes, Your Honor.
problem.
Mr. Levin?
could you say the question again?
Of course, sir. You don't know where you ordered those other drinks.
Right. You could order them at the rooftop or at the bar downstairs. And I just wasn't sure which drink we got from where, but I remember which drinks we got.
You don't remember if Jessica finished her drinks, do you?
No. I remember that they were taken away, but I don't remember exactly which one she finished.
You don't remember in what order you ordered the rest of the drinks that night.
No.
But it's your testimony that you are certain at 10 p.m. Jessica fell down the stairs and ran into the bar's owner.
Yes, she almost hurt herself. I was stressed. I wanted to make sure she was okay. I remembered it, yes.
The bar's owner, you know that that's Sunny Meta, don't you?
That's true.
So this person that Jessica, you say that she ran into, you don't know what they were wearing, do you?
No, I wasn't really paying attention to what they were wearing.
You told us that the person Jessica ran into, they said something when Jessica ran into them, right?
Yes,
You don't remember what their voice sounded like, do you?
I remember it was Sunny.
You don't remember what Sunny's voice sounded like, do you?
No, I knew it was Sunny.
Sir, yes or no, do you remember what Sunny Meta's voice sounded like at 10 p.m.?
I mean, I remembered it was him. I don't know if I could give you a description exactly of like how he said it, but I remember it was Sunny.
Later in the night, you remember paying the tab, don't you?
I do.
You remember signing your name on that receipt?
Yes.
Do you remember doing your math wrong?
I'm not sure. I did it pretty quickly. Jess was trying to leave and I wanted to make sure she was okay.
Would it help if we showed you a copy of that receipt?
Sure.
We'll now be displaying Exhibit 17. Sir, this is the tab you paid that night, isn't it?
It is.
You would agree with me that this is your signature?
Yes.
Defense offers Exhibit 17.
Objection.
Any
to
objection?
hearsay, Your Honor.
Response?
I'm sorry, I didn't hear the grounds for the objection. I apologize.
Objection to hearsay, Your Honor. I apologize.
May
And Ms.
I
Hunt, what's your response? You may.
Yes, Your Honor. This is an automated record from Sunny's Rooftop Bar. This is a receipt. It's an exemption from hearsay.
Response, Your
Response,
Honor.
Mr. Castleberry. Yes.
Yes, Your Honor. Proposing counsel is pointing to 8036, the publicly available business record. Then she needs to lay the foundation that meets the prongs of 8036. Just because this is an automatically generated receipt, doesn't mean it automatically comes in under 8036. We need a custodian. We need someone to verify its accuracy. We need someone to testify to how this process was done. This receipt isn't just automatically admissible because it's a receipt.
Ms. Hunt, your response to that.
Yes, Your Honor. If we could have a little leeway here, later in today's trial, we will be hearing from Sunny Mehta. We can admit the exhibit at that time, as Sunny Mehta will be able to authenticate that under 8036. At this time, I am using this to refresh the witness's memory, and I can enter it later.
Sure, if this is being used for refreshment, that's no problem, but let's not admit it into evidence just yet.
Yes,
Your Honor.
Mr. Levin, we agreed that this is your receipt, right?
It is.
You can agree with me that you did your math incorrectly.
Yeah, I see now. I think it should have been 139. I'm still not good at math, but yeah, it's wrong.
We can take Exhibit 17 down. Sir, you're a STEM major, aren't you?
Bio, it's mostly memorization.
You go to UCLA, right?
Yeah.
Objection, Your Honor. Relevance.
Your Honor, if I may.
You may.
Witness stated that he's bad at math. I'm using this to impact his credibility in this case. If I may have a little leeway, I'm going to discuss the witness's GPA with him.
Response, Your Honor.
Overruled. Let's keep going. It's cross.
Yes,
You
Your
go
Honor.
to UCLA.
I do.
You have a 3.9, don't you?
Yeah.
Sir, when you got in that parking lot, you didn't want Jessica to drive it first, right?
I didn't. No.
But when she got in that car, you thought she appeared sober enough to drive.
I thought so. Sure.
Thank you, Mr. Levin. You have nothing further.
Any redirect?
None, Your Honor.
Anything
May
else
this
from
witness please
plaintiff?
speak?
Yes, thank you.
With that, Your Honor, the plaintiff rests his case in chief.
Okay. Are there any matters before we move on to the defense case?
We're ready to go, Your Honor.
We're ready as well.
Okay, defense, call your first witness.
Defense calls Sunny Mehta to the stand. May we proceed?
Mr. You may.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Hi, my name is Carson Mehta, but everybody just calls me Sunny.
What do you do for a living, Mr. Mehta?
Right now, I'm in between jobs. I owned a little local bar in downtown LA called Sunny's Rooftop Bar. It was my business.
When did you own Sunny's Rooftop Bar?
I think I bought it back in 2017, and I owned it up until 2019.
Did you have to complete any training courses or obtain any certifications in order to run a bar?
Oh, yeah, of course. So in order to run a bar like Sunny's, you have to take a lot of training courses so that you know all the rules when it comes to that sort of stuff. You get certified every 3 years. You have to pass a state exam. And it's not just me. All my bartenders have to do the same thing.
Those courses that you took, what do they teach?
How to serve alcohol responsibly. The main rule is you can't serve somebody if they're obviously intoxicated. So that's what most of the courses go over. How do you know when someone's obviously intoxicated?
Now I'd like to move to why we're here today. Did you serve Jessica Marks alcohol on March 24th, 2019?
Yeah, I did.
When did she enter your bar?
It was March 24th at 9 p.m. probably.
Was she with anyone?
Yeah, she was with her friend, Morgan Levin.
How did Ms. Marks seem when she entered your bar?
I mean, from what I could tell, she just seemed like a normal customer. Looked pretty sober from what I could tell.
Mr. Mehta, did you serve Jessica while she was obviously intoxicated?
Absolutely not.
Objection, Your Honor. Calls for an improper legal opinion. May I be heard?
You may.
Your Honor, opposing counsel just asked Mr. Mehta whether he served Jessica while Jessica was obviously intoxicated. But Your Honor, as we pointed out during pretrial, the obviously intoxicated standard is the legal standard at the center of today's case, and it's an objective one. It's the jury's job to determine based on the facts whether or not Jessica appeared obviously intoxicated. Your Honor, here Ms. Hunt is just asking the defendant for his subjective opinion on that legal standard. And as a result, he's invading the province of the jury, Your Honor. This is not admissible.
Your Honor, if I may.
Response. Yes.
Just because an opinion embraces an ultimate issue does not mean it is automatically objectionable. Further, Your Honor, we have laid the foundation that this witness has taken courses on what it appears obvious intoxication looks like to him. He is able to give the opinion of if someone appears obviously intoxicated. This is a matter of weight, not admissibility. This is why we have cross-examination, and opposing counsel can take the weight of this testimony up on cross.
Response, Your Honor?
Yes, please.
Your Honor, this is a matter of admissibility. Just because Mr. Mehta is certified to identify someone as drunk doesn't mean that's not just his subjective opinion. Your Honor, opposing counsel is asking about a legal standard. They're invading the province of the jury by asking him to determine whether she was obviously intoxicated. Your Honor, that's the jury's job in this case. It's the legal standard at the center of today's case. Mr. Mehta can't just testify to it willy-nilly.
I'm going to sustain the objection. You can ask him whether she looked drunk, intoxicated, but the term obviously intoxicated, let's stay away from.
Motion to strike that testimony, Your Honor?
Yes.
Yes, Your Honor.
Mr. Mehta, let me rephrase. Did you ever serve Jessica alcohol while she appeared to be intoxicated?
No, I didn't.
How do you know?
So like I mentioned earlier, all those courses, they talk about what the signs are that you're supposed to look for. It's pretty straightforward stuff. People slurring their words, they're not talking very well. If they can't walk properly. And every time I was interacting with Jessica, I didn't see anything like that.
Those signs that you just mentioned, did you see any of them exhibited by Jessica's friend, Mr. Morgan Levin?
Yeah, Morgan, on the other hand, he looked a little bit more drunk. He had these...
Yes, Your Honor, speculation.
Response?
Yes, Your Honor. This witness's rationally based perception. He's a lay witness. He's able to testify as to symptoms. Further, Your Honor, we've laid the foundation that this witness is familiar with signs of intoxication.
Response?
Sure.
Your Honor, the question, Your Honor, the answer that Mr. Mehta was giving was that Morgan looked like she was kind of drunk. Your Honor, being drunk is a mind state. This requires speculation to go into the state of mind of Morgan Levin and determine whether or not he was drunk. And again, you actually haven't heard any foundation as to why he thinks that. Mr. Mehta can testify to symptoms, don't get me wrong, but he can't testify that Morgan was definitively drunk without laying that foundation.
Your Honor, if I may.
Sure.
That is not what Mr. Mehta stated. Mr. Mehta stated that Morgan looked, that Morgan appeared, that Morgan seemed buzzed. He is absolutely not delving into the mindset of Morgan Levin. He is testifying to the symptoms that Morgan Levin showed that led him to believe Morgan Levin was buzzed or intoxicated. Those symptoms are not a state of mind.
Response, Your Honor?
Oh, yeah. I think we're good on this. I think whether someone appears drunk is within someone's rationally based perception. Overruled. Make him
Yes, Your Honor.
Mr. Mehta, you were testifying about how Morgan Levin appeared. Could you continue?
Yeah. So those symptoms I was talking about, what I saw with Morgan, he had these really bloodshot eyes. That's the kind of thing you see a lot. And he was tripping over his words every now and then.
Did you ever speak to either Ms. Marks or Mr. Levin about Mr. Levin's state?
Yeah, around 11 o'clock that night, I point to Jessica and then I point over to Morgan and I say, this one's not driving home right. I nodded to Morgan. I was worried about him.
So, sir, to be clear, Did you ask Jessica if Morgan was going to be the one driving home?
Yeah, Morgan was the one who showed those signs.
What did Jessica Marks say?
She said no. She said, I'm the one driving. Don't worry about Morgan. And I was relieved because from what I saw, Morgan had those classic signs of being buzzed and Jessica looked normal.
Was there any specific behavior from Morgan Levin that led you to believe he might have been intoxicated?
Yeah, so right about that same time, around 11, when I was talking to them by the bar, before they left, Morgan went to sign the receipt. And he did it really slowly. He just kind of like stared at it like he was really thinking about it or something. And he was having a little bit of trouble holding the pen.
Would you recognize that receipt if I showed it to you today?
Of course, yeah.
We're now displaying Exhibit 17. Sir, does this look like the receipt that Morgan signed that day?
Yeah, that's the receipt. It's normal for my business. We give everybody a receipt right when they check out.
Are these receipts automated by the bar?
They are, yeah.
Defense offers Exhibit 17.
Any objection?
At this point, Your Honor, given that Mr. Mehta is an appropriate custodian, we have no objection.
Okay, it's in.
Mr. Mehta, does this math look correct to you?
I'm not a math major or anything, but no, it's off by about $10.
We're taking down Exhibit 17. Did Ms. Marks exhibit any behavior that night that made you think she might be intoxicated?
No. Everything I saw, she looked pretty sober.
Mr. Mehta, are you familiar with any videos of Jessica that night?
Yeah. When I was being deposed, the attorney showed me a video of her in the bar.
Would you recognize the video you saw during your deposition if I showed it to you again?
I'm sure I would, yeah.
We're now going to be displaying Exhibit 10, already in evidence. I'm going to go ahead and play this for you, sir, okay?
All right.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
We're taking down Exhibit 10. Mr. Mehta, when you served Jessica Marks alcohol, did she appear that way?
No.
What do you mean?
I mean, if that's how Jessica was acting when I was around, I would have been concerned. My interactions with her were pretty brief, just taking orders and stuff, but it was never anything like that. She doesn't look sober in that video.
Did you ever make a comment about needing to cut Jessica off?
I can't say for sure. But I don't remember making any comment like that. No, I didn't see anything like that.
Did Jessica run into you on the stairs?
No. That never happened. No.
Mr. Mehta, do you know what Jessica's BAC was measured to be at the time of the accident?
Yeah, I was told that. I was told it after the fact. I know now that she wasn't sober that night, but to me, every time I interacted with her was...
Objection, Your Honor, that's knowledge based on hearsay. May it be heard?
You may.
Your Honor, opposing counsel just asked Mr. Mehta whether he knew Jessica's BAC, and the defendant then said, I know now that she wasn't sober that night. He's now testifying to knowledge based on hearsay. That BAC number is actually contained in one of the exhibits from the police report. Your Honor, that's an out-of-court statement being offered for the truth of the matter, sir.
Your Honor, if I may.
You may.
That exhibit has been pre-admitted in today's trial. All objections have been waived.
Response, Your Honor?
Yes.
That's just not true. The police report has not been pre-admitted. It's
Your
not
Honor,
true.
if I may,
Yes.
this information is contained within an autopsy, Exhibit 22, that has been pre-admitted. We can show that on the screen in just a moment for Your Honor's reference.
Response, Your Honor?
So hold on one second. Has Exhibit 22 been pre-admitted? Because I don't recall that.
Yes,
Yes.
Your Honor. 22 has been pre-admitted.
Okay. Has this witness seen Exhibit 22?
Yes,
May I
Your Honor.
respond to that?
Let's hear from plaintiff's response and then defense.
Yes, Your Honor. They need to lay that foundation first. Opposing counsel hasn't asked any questions about whether he saw Exhibit 22, whether he saw Exhibit 23. If they're going to ask him about that BAC, they need to lay that foundation first. The jury needs to see how he knows that.
Okay. Sustain, let's lay that foundation as to how this witness knows about the BAC level.
Yes, Your Honor.
Yes, Your Honor. Mr. Mehta, you told us that you do know what Jessica's BAC ended up being that night. How do you know that information?
So when I was deposed, I was being shown all the documents by the attorneys that they said they might be using. And one of those was an autopsy report. It was in there.
Would you recognize that autopsy if I showed it to you today?
Sure.
In a moment, we'll be displaying Exhibit 22, which has been entered into evidence. Sir, is this what you've seen before?
Yeah, it looks like it.
The section labeled toxicology. Is that where you obtained that information from?
Yeah, it is.
So, sir, if you know what Jessica's BAC was that night, do you know now that she was intoxicated?
Yeah, I know that now, but I didn't know it back then.
Your Honor, I believe that's time.
Thank you, Mr. Mehta. We have no further questions. We can take down Exhibit 22.
Thank you. Cross?
Yes, Your Honor. Good afternoon, Mr. Mehta.
Good afternoon.
You said something interesting on direct examination about Morgan, and I want to ask you about that.
Sure.
You said that you thought that Jessica seemed sober, but that Morgan seemed drunk. Is that correct?
Yeah, it is.
I want to be clear about how much you actually saw Morgan drink. Mr. Hervey, can we get 17 on the screen? Sir, this is Jessica and Morgan's receipt from that night, right? You saw it on direct.
Yeah, it is.
Sir, you would actually say that you don't remember which of the drinks on this list Morgan ordered.
Yeah, it was a group order thing. You know, Morgan's name is on the tab, but they were actually sharing it. They were both getting drinks at the same time. So I couldn't tell you exactly which one belonged to which person.
So that's yes to my question. You don't remember which of the drinks on this list Morgan ordered.
Yeah, that's what I was saying.
You also don't remember which of the drinks on this list Morgan drank.
No, I wasn't there when they were actually drinking them for the most part.
Exactly, sir. You'd also say that you don't remember seeing Morgan finish any of the drinks on this list.
No, like I said, I wasn't there.
Mr. Mehta, you would actually say that you don't remember how much alcohol Morgan drank that night. Do I have that correct?
Yeah, I couldn't give you a number or anything.
But Mr. Mehta, you're claiming today that you didn't believe Jessica was drunk that night. So I want to talk about just how many drinks you served her. Mr. Hervey, can we get that timeline on the screen? Mr. Mehta, you heard Morgan Levin testify today, didn't you?
Yeah, I was here.
You heard Morgan testify that you served Jessica wine, seltzer, and beer?
Right, well, they ordered those as a group. It was just one bottle of wine, so I didn't just serve that to Jessica. I kind of just put them on the table.
Sir, exactly. You were actually the one who took the orders for all those drinks.
Yeah,
You were the one who cleared their table multiple times.
I did, yeah.
And you were the one who brought all these drinks to their table.
Yes, sir.
But despite you bringing all those drinks to their table, you're claiming that Jessica wasn't acting drunk. So I want to show you something. Can we get that video on the screen? Now, Mr. Mehta, you were just shown this on direct. Let's take another look at it.
You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Sir, you heard Morgan testify that video was taken around 11 p.m., right?
Yeah, that's what he said.
Around 11 p.m. You didn't cut Jessica off, did you?
No, like I said, she was never acting like that around me.
You didn't think, well, Jessica, she's too drunk. It's not safe to give her more alcohol.
Absolutely not. That never even crossed my mind.
Well, sir, what you did do was you asked Jessica and Morgan about who was driving home.
Yeah, like I said, I was worried about Morgan.
That's when, like you said on direct, Jessica told you she was going to drive home.
Yes.
Sir, I want to get something straight. When Jessica told you that she was going to drive home, you didn't say you can't do that, did you?
No, sir.
You didn't call her an Uber?
No.
You didn't take her keys away?
No, I didn't.
No, instead, you served them another round of shots.
Yes, sir. The way it works, what I've learned in those classes is that you're not supposed to do anything like that unless you see those signs, and I didn't see them.
Mr. Mehta, I'm not asking about those classes. I'm asking about whether you served them another round of shots, and you did.
Well, yes, because of what I learned in those classes.
You sold her a shot, and then you let her walk out that door.
Yeah, she left.
You're aware that minutes after you let her walk out that door with car keys, she drove off the side of a bridge.
Yeah, I found that out.
Nothing, brother.
Any redirect?
No redirect, Your Honor. We just ask that this witness be allowed to step down.
You are, thank you.
Thank you.
Any other witnesses from defense?
No, Your Honor. Defense rests our case in chief.
We ready to move on to closing arguments? You guys want a minute break?
A minute would be fine. Thank you, Your Honor.
Sounds good. We'll see you back soon.
Your Honor, I do have one quick thing.
Sure. Let's make sure defense counsel is here before we hear it, though.
Yes, Your Honor, during opening statements, I believe both counsels were on the screen. I believe that per the rules, we're actually supposed to go off screen while opposing counsel is presenting. I just wanted to make sure that that happens during closing arguments.
Sure, I'm sure it wasn't intentional on anyone's part. I didn't see it because I'm pinning videos, but yeah, when closing arguments, we'll have everyone's cameras turned off except for the speaker.
Thank you, Your Honor. Sorry for the confusion.
No problem. And are you ready to go, Mr. Castleberry?
I am. Thank you, Your Honor.
You're...
Can you see and hear me okay?
Yes.
Thank you, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. They served, they saw, and they still didn't care. Members of the jury, I know it's not easy to remember everything that's been said on a 2-hour Zoom call. But if there's one moment I want you to remember from today's trial, it's this. On cross-examination, the owner of the defendant bar admitted that Jessica told him point blank, "I'm going to drive home." In that moment, the defendant could have stopped all of this. In that moment, the defendant could have said, "No, you're not." He could have taken Jessica's keys. He could have called her a taxi. He could have told her to stop drinking. In that moment, the defendant could have prevented Jessica's death. But the defendant didn't do any of those things because he was following that course that he took. No, instead, he looked back at the 19-year-old he had been serving drinks all night, and he gave her another round of shots. Did that course teach him to do that? He watched as Jessica took her keys, stumbled out the door, and peeled out of the parking lot. Minutes later, Jessica Marks was dead. You see, members of the jury, that's why Jessica's family brought this lawsuit. See, today, we have the burden to prove to you by preponderance of the evidence that the defendant wrongfully caused the death of Jessica Marks by serving her alcohol, even though she was obviously intoxicated. And members of the jury, we've met that burden. We did that by showing you that the defendant served, saw, and still didn't care. So let's go through those one by one. First, the alcohol they served. Today, you learn just how many drinks the defendant gave Jessica that night. They gave her beer. They gave her liquor. They gave her 3 cans of White Claw, 2 glasses of wine, and a round of shots. For 3 hours, the defendant did nothing but serve a 19-year-old girl drinks. Now, it's true. Jessica chose to drink all on her own. No one here is going to tell you that she made safe choices that night. But under the laws of this state, she was just a kid. And the law tells us that when a kid ends up drunk at a bar, the adults working there have a legal responsibility to do the bare minimum to prevent tragedy. But as you watch this list of drinks get longer and longer, you know the defendant didn't do that. Next, you'll learn that they saw exactly how drunk Jessica was. You saw that video. The defendant wants you to believe that she just wasn't acting like that. You heard that the owner of Sonny's Bar saw Jessica fall down the stairs. He said, "Whoa, we might need to cut this one off." He said, "I hope this one's not driving." The defendant's own words make it clear. He saw what they were doing. But still, you learn how the defendant just didn't care about the danger they put Jessica in. The employees never cut her off, never told her to stop. They just kept feeding her drinks. When Jessica started slurring her words, they gave her more wine. When she fell down the stairs, they gave her more beer. When she said she was going to drive, they gave her more shots. And we all know what happened next. That 19-year-old girl got in her car, drove onto a bridge, lost control of the wheel, and she fell. And we showed you how much alcohol they served Jessica, how they saw Jessica get drunk, and how they still didn't care about their safety. They served, they saw, they still didn't care. Members of the jury, that's wrongful death. But still, the defense wants you to believe that the defendant had no idea Jessica was drunk. He took a look at that video and said, "She wasn't acting like that. I didn't see that." The owner of that bar really got up here and told you that he never saw Jessica act drunk that night? Well, isn't that convenient? Really, all the hard evidence shows that Jessica was visibly drunk and that anyone at that bar would have seen it. Mr. Harvey, can we get that timeline up? Morgan Levin saw it. We got pictures. We even have it on video. See, the defense wants to make it seem like this is just Morgan's word versus Sonny's. But it isn't. It's the word of a defendant who has everything to lose against eyewitness testimony, photographic evidence, and a video that makes clear exactly what happened that night. Besides, members of the jury, the law actually says that the defendant is liable if a reasonable person would have known Jessica was drunk. So it doesn't matter if all the employees at the bar covered their eyes and closed their ears and pretended not to notice the drunk teenager right in front of them. If they didn't see it, then they should have. And the law makes them liable either way. Members of the jury, it's been almost 2 years that the Marks family has been searching for answers. 2 years they've been fighting for justice. There's nothing any of us can do that will bring Jessica Marks back. We know that. But there's one thing you can do. You can make sure that next year is just a little bit easier for Jessica's family. You can hold the defendant accountable for their actions. You can find the defendant liable. Thank you.
Thank you. Closing argument from defense.
Yes, Your Honor. Very briefly before we proceeded to closing arguments, I do intend to use a demonstrative, which is an altered version of the jury instructions. I can show Mr. Castleberry that now.
Yeah, let's see them. Any objection, Mr. Castleberry?
In one moment, there will be a red X.
Apologies, Your Honor. We ought to see the modifications.
These are the modifications, sir.
I think they're up, yeah.
No objections, Your Honor.
Okay, go ahead and use them.
Yes, Your Honor. Counsel, members of the jury, may it please the court. It's about what we knew and when we knew. At the beginning of today's trial, I asked you to keep 3 things in mind. First, when, if at all, did Jessica Marks seem obviously intoxicated on March 24th? Second, most importantly, were any employees of Sunny's rooftop bar there to see it? And third, was Jessica Marks's decision to drive a substantial factor in her death? Now, like I anticipated, plaintiff's counsel, well, they tried to answer that first question and they tried to answer the second. And they pointed you to a couple of instances when Jessica did seem intoxicated. In the parking lot, when they first arrived, where no employees were. And in a video that no employees are present for. And the rest of their evidence, those quotes, that hard evidence that Mr. Castleberry just showed you on the right-hand side of that PowerPoint, rests on the word of a witness who was so intoxicated he couldn't add $20 by the end of the night. Members of the jury, the question before you today, it's not if Jessica was 19. It's not if Jessica was intoxicated. The question before you today is if Jessica was served while obviously intoxicated. The plaintiff had to prove that to you today, and they couldn't. Now, in just a moment, you'll get the chance to deliberate. The judge will give you a few instructions and what we call a verdict form. The very first question on that form is what I asked you at the beginning of today's trial. Did they prove that Jessica Marks' death was caused by the defendant, Sunny's rooftop bar, serving alcohol to an obviously intoxicated minor? Members of the jury, we went over the signs of intoxication. The bar owner, the sober bar owner, told you Jessica was not slurring her words. She did not have bloodshot eyes. She was not obviously intoxicated. Members of the jury, the evidence points to the answer to that question being no. This case should end right here. But in case you find yourself saying yes, you'll be asked a second question. Something else I asked you to keep in mind. Was Jessica Marks' decision to drive that night, to drink and to get behind the wheel, a factor in her death? This is not an easy question. It's uncomfortable to look at the actions of someone who died just a few minutes later. I understand that. But the law requires us to look at everyone's actions, no matter how uncomfortable. And the fact of the matter is, members of the jury, Jessica started the night by drinking and driving to a bar. That timeline, it's important, as we saw with Morgan Levin, because Jessica drank and then got behind the wheel at 8:30. From 8:30 to 9 o'clock, she wasn't drinking. And when she had to, when she was behind that wheel, she appeared sober, even though she wasn't. But when she got out of the car in the parking lot, no employees were there. She wasn't behind the wheel anymore, so she showed a couple signs of intoxication. But when she walked in that door, she knew she was 19. She knew she wanted to be served. She knew she had to appear sober, and so she did. When she was ordering drinks, she didn't want to be cut off. She didn't want to be kicked out. She had to appear sober, and so she could. When she walked outside, when she walked into that parking lot, no employees are present anymore. At first, her friend is concerned. He says, I have an Uber, just get in the Uber with me, Jessica, you can't drive home. But then, in his own words today, on cross-examination, Mr. Levin admitted that Jessica convinced him that she was sober, that even though she was intoxicated, she was able to appear sober enough to drive. Members of the jury, the best friend couldn't even tell that Jessica was too intoxicated to drive. She wasn't exhibiting signs. The question before you today is if she was obviously intoxicated, and the answer is no. But if you get to that second question, if you have to ask yourself, did her actions play a role in her death? Did her decision, the decision she made alone to drink and get behind the wheel, play a role in her death? You'll be asked a third question. You'll be asked to do what's called apportioning fault. If you find that Sunny's rooftop bar, they did serve her alcohol, but that nobody made her get behind the wheel, that was her decision, you can assign some fault to Jessica. I know that is an impossible question, and you don't have to get there. Because if you find that the plaintiff failed to meet their burden, that they failed to prove that Jessica was obviously intoxicated, you don't have to get there at all. Members of the jury, the signs, the symptoms that he wants to keep talking about, that Mr. Castleberry keeps bringing up, they weren't exhibited to anyone at Sunny's rooftop bar. No employee was in that parking lot. No employee was present for that video. The symptoms he wants to tell you, that Jessica fell down the stairs, the only person who can tell you that is Morgan Levin. Morgan Levin couldn't identify who Jessica even ran into. Couldn't identify what they were wearing. Couldn't identify their voice. I don't know if that happened, much less if it was the bar owner. You have to ask yourself, who's more credible? The word of an intoxicated 19-year-old or a sober bar owner who was trained to know better? They failed to meet their verdict. In a few moments, when you go back to deliberate, you'll be asked some difficult questions. But in just one more moment, Mr. Castleberry will come before you again. And it's gonna seem like he has the last word, but he doesn't. And neither do I. You do. You have the obligation, the opportunity, the power to apply the facts to the law without bias and without prejudice. And once you do, I'm confident that you will find Sunny's rooftop bar not liable. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor.
Go ahead.
Members of the jury, they just asked you a whole bunch of questions. Let's answer those. When, if at all, did Jessica Marks seem obviously intoxicated? The whole night. Were any employees of Sunny's rooftop bar there to see it? Yes, Jessica fell down the stairs into the defendant. Was Jessica Marks' decision to drive a substantial factor in her death? He gave her shots after she told him he was going to drive. Members of the jury, we knew exactly what he knew, and we know exactly when he knew it. Find him liable. Thank you.
Thank you. We're going to have the judges submit their ballots, and then once all the ballots are in,
Right before you
we'll
went up,
hear some
she said,
feedback.
I'm sorry, I lied. You only get 5 seconds left.
Apologies, Your Honor.
I think we're good, right?
I believe so,
Thank you,
yes.
guys. Judges, if you can submit your ballots, and then once they're in, I'll let you know, and we can pop on for some feedback.